Good afternoon. I'm very happy that I can talk about Polish family here. Let's start. In Poland, the exclusive competence to intervene with parental authority is rests with the courts. Foremost, it is necessary to differentiate between a limitation and modification. The limitation is about parental authority, which is a form of court interference due to a threat to the good of the child. The aspect I will mainly focus in my presentation. And the modification of a scope of parental authority based on other reasons. For example, its termination ex lege due to the incapacitation of the parents. Good grounds for a limitation of parental authority are situations when the good of the child is at risk and when the good of the child has been threatened. The source of the threat usually is to be found in the behavior of parents. Sometimes the behavior is highly reprehensible and they bear culpability, but sometimes it is the result of badly conceived care or an inability to properly fulfill parental duties. The good of a child may be also threatened as a result of the behavior of one parent, while the behavior of another parent does not raise objection. Irrespective of cause, limitation of parental authority is not a form of repression toward parents whose behavior puts the good of the child at risk. The sole purpose of such a decision is a protection of the child's good. Obviously, parents may see this decision as an act of disapproval of their behavior, which in fact is often justifiable. This disapproval is, however, a manifestation of such a decision, not its aim. If the good of the child is threatened to either of the above ways, the court is obliged to react by issuing an appropriate decision. And just what is such an appropriate decision? This depends on the court has aim is to remove a threat or contain a situation that compromises the good of the child. The term decision, one that the court is obliged to make, also implies that the situation shall be dealt with immediately without delay. Certain situations have always posed a threat to the good of the child, and they continue to do so. Apart from them, new circumstances can emerge, and they sometimes generate controversies. Some people classify the circumstances as posing a threat, while others see them as benign. The former expect the court to react to the threat, while the latter posit that any reaction would be a sign of oppression directed against the autonomy of the family. There are some causes that generate danger to the good of the child, and they call for interference from the court that do not raise any doubt. These are violence of parents towards the child, each other and others, neglect of the child, neglect of contact with the child, and so on. More attention will be paid to those causes and situations that generate some doubts of controversies. One, abuse of intoxicants. At present, the most serious and immediate threat to the good health and life of the child is alcohol consumption by pregnant women. The doctrine has formulated a draft amendment to the Family Guardianship Code, allowing the court to order forced hospitalization of a woman who consumes alcohol or uses drugs as their intoxicant while pregnant. 2. Poverty. Family Guardianship Code prohibits placing children in forced care in the sole reason for a threat to the good of the child is poverty. Interference in family life can also be experienced by people who are trying to fulfill their parental duties and who have a good relationship with their children. They sometimes badly manage their lives or have lost their jobs through no fault of their own, are chronically ill, and are otherwise poverty-stricken. In such cases, much support should be mobilized for the family before the cases are taken to the court. 3. Prevention or obstruction of a contact of a parent who does not reside with the child and manipulation of a child against the other parent. In Poland, legislative provisions providing for a penalization of the obstruction of contacts have been drafted. Resorting to administrative or punitive measures to enforce fulfillment of family legal duties is nothing new. Taking away a driver's license from maintenance debtor or imprisonment for the paying maintenance. Such measures, though were seen as justified, only when family legal sanctions proved to be ineffective. Unfortunately, courts do not limit the parental authority of the parent who limits their contact with the other parent. This circumstance requires immediate changing, and in such situations, the appointment of the probation officer seems to be a proper form of limiting parental authority. 4. Refusal of permission to implement a medical procedure and refusal to subject a child to mandatory vaccination. This act is sometimes motivated by religious reasons, often when the procedure requires a blood transfusion. Sometimes, however, the refusal may result from a legitimate fear about the child's life in a situation when, to the best to medical knowledge, the procedure seems indispensable. A similar problem arises when parents do not agree to the hospitalization of a child or intend to check the child out of the hospital when the health of the child dictates that the child should stay in the hospital. Generally speaking, in such a situation, it is a legal duty of a doctor or healthcare institution to inform the court to issue a substitute consent that replaces the declaration to intention of an authorized subject. Before the COVID pandemic, the issue of mandatory vaccination had long generated heated debate. We might have accounted for the reluctance of the political authorities to impose mandatory vaccination during the recent pandemic. By declaring the vaccination against the virus voluntary, it was possible to avoid greater social unrest as well as the accusation that the political authorities were violating family autonomy and the primacy of parents in raising children. It is mandatory for parents to subject children to some selected vaccination, and violation of this obligation provides grounds for administrative legal sanctions to enforce the duty, for example, by a fine. In cases when this measure fails, the health care unit is bound to inform the court about a threat to the good of the child. Interference in parental authority here is admissible when administrative measure fail. 5. Sharenting. This word made of two words, share plus parent. This concept denotes behavior of parents who upload information about their children on social media, including their images, pictures, or films, thus violating the right of the latter to privacy. The short and long-term effects of this phenomenon are easy to foresee, such as loss of control over the published material, which may be used for criminal purposes. In particular, photos and films of naked children may be intercepted and published on pages showing children pornography. This action unduly exposes children, making them more vulnerable to violence and harassment to peer or by other people commenting of the material available in cyberspace. Parents that are involved in sharenting are rarely aware of the danger it poses to the good of the child. 6. Violating the autonomy of a child. Abridging of child's privacy may be justified when it is not arbitrary or unlawful. A case in point may be a very strong suspicion that the child might be involved in the distribution or use of drugs or any other criminal activity. Much controversy is aroused by the use of smart tech devices by parents to spy on their children. In a majority of cases, installing forms of spyware in a child's phone that informs the parents about the whereabouts of their child results from a need to care about children's safety. However, in no way does this intention excuse parents' behavior, as it violates children's right to privacy, in particular of teenagers. It is even more difficult to judge well-intentioned care as justifiable concerning the parents who violate their children's privacy by browsing through their email. Parents also find it difficult to respect children's autonomy in regards to their worldview. In practice, this boils down to quarrels with children about their participation in religious classes at school. A child often attends classes at the parent's request, so parenting and legal issues occur if, against the will of their parents, a child wishes to attend such classes or refuses to attend them. If the disagreement leads to an acute conflict or an attempt to use psychological or physical violence, the good of the child may be endangered, which can make it necessary to interfere in parental authority. Something about forms to interference in parental authority on the grounds of Article 109 Family Guardianship Code. The Family Guardianship Code lists several ways to interference with parental authority, which all imply its limitation, yet the list is incomplete. the court may limit parent authority in many ways, including some not mentioned in Article 109. With reference to one family unit, the court may order two or more forms of limitations in different arrangement. The code mentions a wide range of forms of interference from the mildest to the harshest, which the placement of a child outside a family. Procedural and organizational remarks. A characteristic feature of many remedies concerning parental authority is the possibility to amend it if the good of the child dictates this. Metaphorically, this feature can be described as a tailor-made approach. It assumes that the harshest remedy should be applied if the milder remedies have not produced the expected effects. This means that if the recommended family therapy or the support of family assistant has proved ineffective, then supervision of the probation officer may be established, or a child can be placed outside family, or parents may be deprived of their parental authority. Of course, this tailor-made approach ideally works both ways. That is also in the situations when the desired effect is achieved. When this happens, any prior harsher remedy should be replaced with a less stringent, more lenient one. The institutions that are bound to inform the court about negative and worrying situations in the family are also obliged to provide information about positive changes. The act of interference by the court in parental authority, in particular in the form of limiting it, is essentially an act of a legal institution which, perhaps as with any other institution, forces judges to cooperate with out-of-court institutions. Among the institutions that a court must, should, or at least might collaborate with, several can be mentioned: a family assistant, social worker, and so on. All the institutions hire specialists of different fields, such as psychologists, sociologists, pedagogues, lawyers, social workers, doctors, family studies graduates, administration staff. Viewing the above-mentioned institutions and persons from the point of view of a judge, it should be emphasized that, 1, they signal problems to the courts because they function in direct contact with families and have first or second-hand knowledge of them from subjects that perhaps would not have approached the court with the information themselves. 2, they can and should share their knowledge in the course of evidence proceedings. 3, they carry out decisions often being in a long-term relationship with the court. 4, they report to the court the state of affairs in the family receiving support, which has an impact on the content of court decisions. However, all of them suffer from staff shortages, the long-term consequence of which is that the court decisions, especially those made on the basis of Article 109, cannot always be fulfilled. When analyzing a particular case, a family judge should coordinate the actions of each of the institutions. This very much depends on how much the judge knows about the local environment and about the competences and methods applied by the institutions that execute judges' decisions. Because coordination is a demanding task, a judge is expected to be communicative. This is also assumed that family courts will employ people who fit or match an appropriate personality profile. At the very least, it is expected that they prevent the employment of people whose personality does not predispose them to properly carry out the responsible social functions of the family judge. To conclude, the issue of interference of parental authority can serve as a springboard for a discussion about the model of family support, especially of how to support a family affected by diverse problems, often referred to as dysfunctions, economic, educational, and others. The issue is complex in terms of jurisprudence. Moreover, as it is related among very things to psychology, pedagogy, social work, any form of action on interference requires the cooperation of the court with many persons and institutions that make up the local infrastructure of family and children support. Among the specific issues related to the interference of parental authority, at the forefront is the search for an optimal formula for family justice and the most desirable professional profile of a family judge. Thank you for your attention.